Good morning, Mr. Solicitor.
Yeah, good morning.
I'm Marlene Autumn from Hanscom and Wells Solicitors of Fortitude Valley. I have this case of a young woman who sexually assaulted by an unknown assailant at local nightclub. A May Esther, another club patron, who found the victim crying and upset at the time of incident, where the victim told me Esther in detail what has just transpired in the sexual assault on that night. The police officer was called and have recorded the victims and made Esther's statement about the sexual assault. The defendant was referred to us, and our office has received the brief of evidence from the prosecutor's office regarding this matter. I wanted to hear your opinion, Mr. Solicitor, about this out-of-court statement.
May Esther, um, in a statement, an oral testimony, can she give evidence about the female assault victim? Assault victim told her about the attack.
May Esther walks to the toilets and finds the victim crying and upset at the time, and she told the police officer about the sexual assault by the victim.
Yeah, right. That's hearsay.
Yes, it is a hearsay. However, there are exceptions to the rule. According to the Evidence Act 1977, Section 92, the admissibility of documentary evidence as to facts in issue. The subsection 1 stated that in any proceeding, not being a criminal proceeding where direct oral evidence of fact would be admissible, any statement contained in a document intending to establish the fact shall, subject to this part, be admissible as evidence of that fact if the maker of the statement had personal knowledge of the matters dealt with the statement and is called as a witness in the proceeding. So it is possible that May Esther's testimony would be admissible and she can be a witness before the court.
So, well, let's find out. Tell me some more.
Uh, Alright. Police were called and the female constable talked to both women and took down details in their official police notebook. She records the victims in Esther's statement and also what May Esther was told about sexual assault by the victim.
Yeah, right. Um, yes, yeah. See, um, do you consider the police record and notebook would be admissible in court?
Yes, I believe. According to the Evidence Act 1977, Section 92, Subsection 1, Subsection D, the document is a form part of record relating to any undertaking and made in the course of that undertaking from information supplied, whether directly or indirectly, by persons who had or may reasonably be supposed to have had personal knowledge of the matters dealt with the information they supplied, and the person who supplied the information recorded in the statement in question is called as a witness in the proceeding. So, the notebook and police record and are evidence and would be admissible in court as long as the witness can testify to her personal knowledge of what has occurred.
Yeah, yeah, that's a tough one. Yeah, do you know any reference or doctrine related to that?
Yes, I know one. It is called Doctrine of Res Justa. It is an exception to the hearsay rule. Res Justa literally means the transaction. It refers to events which can be considered as part of the story to which the event in question relates.
Yeah, okay. Yeah. We explain why it is an exception um, to the hearsay rule.
Yes, there are two aspects to the doctrine of res justa when it applies as an exception to hearsay. And these are one, approximate contemporaneity, with the event in issue, and spontaneity, it must be spontaneous.
Yeah, okay. Do the notes of the police officer in a notebook fall within the doctorate?
Yes,
And why is that?
um, if something occurs close in time to the event in question, then there is less chance that the person is concocting what happened or making errors. This doctrine extends particularly to spontaneous statements made as a reaction to situation without much apparent thought. This makes the evidence overwhelmingly relevant and reliable such that it will be admitted despite the hearsay rule. Also, the doctrine of res gestae emphasizes the spontaneity of statement, which indicates that the event is still dominant in the mind of statement maker, and hence most likely to be true and thus reliable.
Yeah, okay. Yeah. Yeah, it's good to know that.
Um, yes.
Yeah, right. Well, really, could you explain why
Um,
this is?
The Evidence Act 1995, Section 59, subsection 1, subsection 2, explained that hearsay rule that representation made by a person is not admissible to prove the existence of fact, that it can reasonably be supposed that person intended to assert by the representation. And this is called asserted fact. However, the exception is the opinion of laypersons will be accepted in a situation where an ordinary person with no specialized knowledge gives an opinion on their perception of situation. Like what have been described in the Evidence Act 1995, Section 78, which outlined the exception of lay opinions. It stated that the opinion rule does not apply to evidence of an opinion expressed by a person if the opinion is based on what the person saw, heard, or otherwise perceived about a matter or event. And the evidence of opinion is necessary to obtain an adequate account of understanding of the person's perception of the matter of event. So, May Esther can give her lay opinion and may accept it in court as evidence. Though she doesn't have specialized knowledge, her opinion is based on what she saw and heard. The victim was upset and crying, and that was the appearance of the victim when May Esther saw her. And her opinion on the account of the event is adequate to prove that she had knowledge of the incident.
Yeah, okay. We must delve into this matter precisely. Um, let's work this one out.
Thank you, Mr. Solicitor. I look forward to hearing from you.
Yeah, you're welcome.
Thank
Thank you
you.
for coming.
Thank you.